Hello, good morning everyone. So today we are going to discuss the legality of the DNA Technology Use and Application Regulation Bill 2019 and right to privacy. Okay. This legality of the DNA Technology Use and Application Regulation Bill 2019 and the right to privacy. You would be thinking that every new dimension is revolving around or is centered around this issue of right to privacy. Because we have delved so much deep into the new technology and our lives have become so mechanical and technologically dependent that we have already compromised much of our personal lives with the other unknown people, unknown entities. Because just carrying an Android phone, is a blatant violation of the right to privacy. But somehow we try to ignore these facts because these kinds of things are like have become so necessary in our lives that it has become really pertinent to live with them. Okay, we really can't ignore the use of mobile phones despite knowing the fact that it is very difficult to keep your things private if you are carrying Android phone with you. Okay, I guess I'm audible and visible to you. I cannot see any live chats here right now. Please assure me that you are there. Okay. The DNA Technology Use and Application Regulation Bill 2019 was introduced in the Lok Sabha on July 8, 2019. The bill seeks to formulate a DNA regulatory board with a mandate for establishment of DNA data banks and accreditation of DNA profiling laboratories. The DNA Technology Use and Application Regulation Bill 2019. Now this is the new bill. Okay, this DNA Bill 2019 is a new bill which was recently introduced in Lok Sabha on July 8, 2019. Okay, the bill seeks to formulate new guidelines for dealing with the. Okay, so many people are there. Okay. The bill seeks to formulate a DNA regulatory board with a mandate for establishment of DNA data banks and accreditation of DNA profiling laboratories. Okay, we already know this fact that the collection of DNA is very important in determination of most of the crimes. Okay, the crimes which take place like in crimes like murder, in crimes like rape, the DNA sampling is very important. DNA sampling, takes us directly to the person who is directly to the perpetrator or the offender who has committed the crime. For example, in cases of rape, the DNA samples are collected from the traces of semen that are left over the body of the victim by the perpetrator, and then out of that DNA sampling, it becomes very easy for the investigating agencies to find out the person who has committed the offense of rape, right? So DNA samplings are very important. Sometimes they are also used in the cases of missing persons. Okay, DNA sampling is used. Okay, so in cases of murder, for example, if a person has touched anything, okay, even if he has dropped his hair somewhere, this will help the investigating agencies to collect the DNA sample out of anything that he has, touched, and it becomes very easy to reach the perpetrator and apprehend him. So this is why it was important. But at the same time, what is of what is the concern? The concern is that that this DNA sampling does not always necessarily takes us directly to the perpetrator. Sometimes there are other peoples also who are at the crime scene, and this violates privacy also. Even if the offender is there and his DNA samples are collected, then also it is a cause of concern that what about the right to privacy of any person, be it the perpetrator. Okay, the bill seeks to formulate a DNA regulatory board with a mandate for establishment of DNA data banks and accreditation of DNA profiling laboratories. 5 categories have been identified under which data indices are to be maintained, which include crime scene index, suspects or under trials index, offenders index, missing persons index, and unknown deceased persons index. Okay, there are 5 categories which have been identified under which data indices are to be maintained, which include crime scene index. Okay, now look at this very carefully. This DNA bill has created 5 categories, okay, which data indices are to be maintained, which include crime scene index, okay, suspects or under trial index, okay, offenders index, missing persons index, and unknown deceased persons index. That's how any DNA sampling is categorized into 5 groups. The bill has raised concerns on multiple levels. The most serious of the lot being DNA profiling in criminal offenses and its violation of the fundamental right to privacy. Okay, now this is the cause of concern, that DNA profiling in criminal offenses leads to complete and a blatant violation of the fundamental right to privacy, because DNA is something which is connected to your bodily autonomy and which is extremely personal to an individual. So the DNA sampling without the consent of an individual, or the DNA sampling of an individual without his consent, is a cause of concern. Have you understood this? Have you understood this point? Consequently, one of the heavily debated provisions of the bill relates to consent of accused persons for their DNA samples, bodily substances for the purpose of profiling. Clause 21 of bill states that for offences punishable with imprisonment of more than 7 years or death, the consent of accused is not required to be taken by the investigating agencies. In all other cases, a written consent must be obtained from the persons whose sample is to be collected. In the absence of this voluntary consent, a magisterial order could be obtained. Okay? Have you understood this point? Consequently, one of the heavily debated provisions of the bill related to the consent of accused persons for their DNA samples, bodily substances for the purposes of profiling. Okay. Consent of the accused persons is very necessary. I told you DNA sampling of an individual is done without his consent. Okay. Like for example, if any person is accused of committing any offense, then his DNA, in cases of collection of scientific evidences, his DNA samples can be collected, and there's no provision for seeking the consent. So this is the most heavily debated provisions of the bill, that the consent of the accused persons for their DNA samples, bodily substances for the purpose of profiling, that the consent has to be sought. Okay. The investigating agencies, without seeking the consent, they go ahead while Please tell me if you have understood this point. Have you understood are you getting my point or not? Clause 21 of the bill states that for offences punishable with imprisonment of more than 7 years or death, the consent of accused is not required to be taken by the investigating agencies. See, this is clause 21 of the bill, which states that for offences punishable with imprisonment of more than 7 years or death, the offences which are punishable with imprisonment of more than 7 years are heinous offences mostly. Okay, in 7 years or death, like murder, like rape. Okay, these are heinous offences. So clause 21 of the bill states that for offences punishable with imprisonment of more than 7 years or death, the consent of accused is not required to be taken by the investigating agencies. In all other cases, a written consent must be obtained from the person whose sample is to be collected. This is the point of concern, right? Okay. In case of heinous offences or offences which are punishable with imprisonment of more than 7 years or death, the consent of the accused is not required, and this is contained under clause 21 of the bill. In all other cases, a written consent must be obtained from the person whose sample is to be collected. Okay, in all other cases, like in all the other offences which are punishable with imprisonment of less than 7 years, okay, the written consent must be obtained from the person whose sample is to be collected. In the absence of this voluntary consent, and if the consent is not present, or in the absence of such voluntary consent, a magisterial order could be obtained. Clause 21 subclause 2. Okay, clause 21 subclause 2 says that in case the consent cannot be obtained, voluntary consent cannot be obtained, then a magisterial order can be sought on this issue. You know, the police can put this plea before the magistrate concerned that we should be given this permission to do this DNA sampling of this particular accused person. This provision is a clear violation of right to privacy as recognized in KS Puttaswamy versus Union of India. A very landmark judgment case, we all know this, we read this every day. Justice KS Puttaswamy versus Union of India. Okay. Now, possible misuse of DNA database. How the DNA databases are possibly misused or can be possibly misused. That is important. At the onset of the debate, one could argue that the immediate result of DNA profiling would be beneficial to the state on grounds of giving the investigative agencies potential leads, and that the same outweighs the privacy considerations of the citizens. Okay, privacy considerations of the citizen, that's very fine, that's easily understood. Okay, that immediate result of DNA profiling would be beneficial to the state on grounds of giving the investigative agencies potential leads. Like DNA sampling gives the investigative agencies a breakthrough in the investigation process, and it becomes very easy for the investigating agencies to reach and apprehend the perpetrator right away. Okay, but this privilege, this advantage of DNA sampling, it outweighs or overshadows the privacy considerations, because it hardly pays any heed to the privacy considerations of the citizens. That whatever comfort and whatever relaxing procedure it might be for the investigating agencies, it is at the same time blatantly violating an accused's right to privacy. Okay. However, such an argument fails to consider the fact that violation of privacy lies not only in the immediate collection of bodily samples for DNA profiling, but also in the possibility of its future manipulation by state agencies. Okay. However, such an argument fails to consider the fact that the violation of privacy lies not only in the immediate collection of bodily samples for DNA profiling, but also in the possibility of its future manipulation by state agencies. Okay? Right? Understood? Violation of privacy lies not only in the immediate collection of bodily samples for DNA profiling, but also in the possibility of its future manipulation by state agencies. The privacy violation starts right at the stage of the collection of DNA samples. If investigating agencies are collecting your DNA samples, your privacy violation starts right away. And the intensity and the gravity of this violation increases when there is a possible scope of a misuse of such DNA samples by the state agencies in future. That becomes more grave and more intense. That is important. Okay. Misuse of such information could be in the form of planting of evidence against repeated offenders, data sharing with interested private parties such as pharmaceutical and insurance companies, unwanted familial searches, etc. Members of a familial group can become highly susceptible to scrutiny because DNA profiling could lead investigative agencies to arrest people based on their genetic makeup and not on any reasonable grounds of suspicion. Okay, misuse of such information could be in the form of planting of evidence against repeated offenders. Planting of evidence against repeated offenders. Like the state agencies in most of the cases, they in order to take a shortcut in the investigation process, they can plant the evidence against repeated offenders. Okay, like there are recidivists, that means recidivist. Who are recidivist? The repeat offenders are known as recidivists, and this tendency to commit the offenses again and again repeatedly, this is known as recidivism. I have already told you, I remember I told you this in some of my lecture before, that this tendency to repeat the offenses is known as recidivism. Recidivism. Okay, recidivism. And the repeat offenders, they are known as recidivist. Okay, so these state agencies, the investigating agencies who are actually disturbed and have really got frustrated from the repeat offenders, it becomes very easy in the DNA sampling cases to plant the evidence against the repeated offenders and put them behind the bars forever. Okay. Data sharing with interested private parties such as pharmaceutical and insurance companies, unwanted familial searches, etc. Members of a familial group can become highly susceptible to scrutiny because DNA profiling could lead investigative agencies to arrest people based on their genetic makeup and not on any reasonable grounds of suspicion. Okay. Now, the DNA profiling leads the investigative agencies to arrest people on their genetic makeup. Okay, perhaps I may share because of being from the same family. For example, if you have a big family and there's one accused in your family, then all the people who are related with him in such cases, all the people are related with him and they are going to share some DNA resemblances. Okay, there will be some DNA resemblance in all the members. So based on genetic makeup, simply based on genetic makeup, a person cannot be arrested. Okay, and not on any reasonable grounds of suspicion. While this may make the job of investigative agencies easier, it introduces a fair degree of arbitrariness in the application of law. Although DNA profiling is unique, but strong familial similarities can compromise the privacy of the family members of those people who are on the national database. Okay? Who are on the national database, because it compromises the privacy of the family members also. Once the DNA is gone, all the people who are by blood connected with the accused person, their privacy is also indirectly violated in such cases. Okay, although DNA profiling is unique, but strong familial similarities can compromise the privacy of the family members of those people who are on the national database. Right? Have you understood this? Now, absence of a data protection law. What is the data protection law? We have this personal data protection bill of 2019. We have just read it the day before yesterday. We learnt about the personal data protection bill also, and the other Disha. Okay, so there we have, up till now there is a legislative void on this data protection. There is a legislative void. The Planning Commission of India had constituted a 12-member group of experts which gave 5 features of right to privacy. Okay, the Planning Commission of India, which is now known as Niti Aayog, had constituted a 12-member group of experts which gave. Shalvi is asking any case on DNA misuse. See, I cannot cite any case on DNA misuse up till now. The author of this article is trying to say, Shalvi, that there are possibilities of such DNA misuse in the future. Okay, this might happen, and in cases where this has happened, some of the cases might have gone unreported. Okay, might have gone unreported. So right now it is very difficult for me to cite any case on DNA misuse, but these may be assumptions, or these may be apprehensions of the writer of this article. Okay, these are just apprehensions, or you can say the far-reaching understanding of the author of this article, who is trying to find out the loopholes in the whole DNA mechanism. Okay. Now, the Planning Commission I was telling you, which is now known as Niti Aayog, had earlier constituted a 12-member group of experts which gave 5 features of right to privacy. One of the 5 was the recognition of right to bodily autonomy and personal data protection. Bodily autonomy and personal data protection. Subsequently, the draft Personal Data Protection Bill was introduced in the Parliament with an aim to regulate the use of a personal data of citizens by the government and private companies. It included consent-based usage of sensitive information like biometrics, financial information, and even religious beliefs. So we have already learnt a lot about Personal Data Protection Bill. Okay, what it does, what this bill aims to do. This bill aims to regulate the use of a personal data of citizens by the government and private companies. It includes consent-based usage of sensitive information like biometrics. Like, the issue of consent is involved in PDP also, in Disha also. Okay, that your biometrics means your bodily information, like the information which is contained in your iris scan, and which is contained in your Aadhaar card, which is coded. There is a barcode which is made on your Aadhaar card. That barcode contains your bodily information, your biometric information. What is that biometric information? Your iris scan and your fingerprints. Okay, these are sensitive informations. But these sensitive informations, the collection of these sensitive informations and their regulation and storage and transmission has to be regulated by the consent of the person concerned. Before your biometrics are collected, your consent should be sought. This is what the Personal Data Protection Bill says. Financial information. If you're sharing your financial information, your consent must be sought before this. And even religious beliefs. Okay, whatever religious faith, whatever religious beliefs I hold is completely my personal choice. And before I share my religious beliefs and my personal views on religion with anyone, wherever they are needed, my consent should be sought. The bill seemed like a step towards a more restricted and consensual use of personal information by government machineries. But right now, the PDP bill, since it is not in force, the DNA sampling is done without a legislation, or there is no current regulation of the DNA sampling. This is what is important. Okay. Yes, Ankita, without consent, it cannot proceed. Okay, so the 5 features of data protection are, there are 5 features of data protection, I mean 5 features of right to privacy. One of the 5 features of right to privacy is bodily autonomy and personal data protection, on which a draft personal data protection bill is already pending in the parliament. Have you understood this paragraph? Any confusion? Have you understood or not? Any confusion? Please tell me. But what exacerbates the situation against DNA technology bill is that even the draft Personal Data Protection Bill 2019 is not modeled to protect the citizens against the grave privacy violations which the DNA technology bill poses. Okay. The situation against DNA technology bill is that even the draft Personal Data Protection Bill is not modeled to protect the citizens against the grave privacy violations which the DNA technology bill poses. The author of this article is trying to tell us that this new DNA technology bill is not modeled on the lines of personal data protection bill, because it is not solving or giving solutions to the issue of privacy violations in the DNA technology bill. Like the Personal Data Protection Bill protects the personal information and biometric information of an individual by invoking the principle of consent, same is not the case with DNA technology bill. Section 43 of the PDP bill creates an exception for the investigation and prosecution of offences and exempts the observance of the strict standards for the same. That means Personal Data Protection Bill itself says that in cases of crime, in cases of investigation and prosecution for offences, strict standards for the violation of for the protection of privacy should not be observed. That means the investigative agencies have been given a free hand to collect the DNA samples and do the DNA samplings as and when they want without any consent. They hardly require any consent here. Okay, this is the PDP bill itself says. Section 43 of the Personal Data Protection Bill is protecting the individuals, every individual's personal information, biometrics, financial information, religious beliefs, everything. But Section 43 of the same law says that you don't need any consent in cases of investigation and prosecution of offences, and no strict standards for the protection of privacy are to be observed here. Have you understood this? This is important. Therefore, any violation of the privacy of accused persons and their family members under the DNA technology bill could possibly be justified under such an exception. Okay, any violation of the privacy of accused persons and their family members under the DNA technology bill could possibly be justified under such an exception. This is important. Okay, any violation of the privacy of accused persons and their family members under the DNA technology bill could possibly be justified such an exception. Now the investigative agencies would take this as exception as taken for granted. Okay, and they will go ahead and with the DNA sampling without seeking any consent of the accused person. This is dangerous. This is a dangerous precedent which the PDP bill and the DNA technology bill together create or together poses. Have you understood this? Okay, now while a full-fledged act on privacy may seem to be a far-fetched dream, the landmark Puttaswamy judgment can be used as a parameter to check DNA technology bill's legality. Okay, The landmark Puttaswamy judgment can be used as a parameter to check DNA technology bill's legality. With respect to the same, we argue that the DNA bill would fail three-pronged test of legality, necessity, proportionality. We have read earlier about this, that in cases of proving any legislation, any executive policy of the government as unconstitutional on grounds of the violation of privacy, we have to see or justify its constitutionality. We have to see its legality, its necessity, and its proportionality. If these three things are proved, the legislation which seems to violate any privacy or which happens to violate any privacy will be justified on constitutional grounds. Okay. So at least we can check the DNA technology bill's legality on these three grounds or constitutionality on these three grounds. We argue that the DNA bill would fail the three-pronged test of legality, necessity, proportionality as laid down in the Puttaswamy judgment. Okay, then violative of Article 20 Clause 3. This is important. What does Article 20 Clause 3 says? See, Article 20 Clause 1 has protection against ex post facto law. There cannot be any criminal law. There cannot be any criminal law with a retrospective effect. This is known as protection against ex post facto law. You all know this. Article 20 Clause 3 contains protection against double jeopardy. No man shall be punished for the same offense more than once. Article 20 Clause 3 contains protection against self-incrimination. That every individual, every citizen has a right to protection against self-incrimination, that no man shall be compelled to be a witness against himself. And when we say witness, this is simply does not mean the oral testimony. This includes all kinds of evidences. If I am accused in a case, God forbid, and is there any document or any material evidence which I have, which I possess, I should not be compelled to produce it before the investigating agencies, because this would amount to my violation of right against self-incrimination. This is simply not restricted to any oral testimony. This is rather extends to giving any kind of evidence, be it the oral evidence, documentary evidence, scientific evidence, material evidence, or anything. So if you think that DNA sampling, what about the DNA sampling? If you have committed the offense, for example, and you don't want your DNA samples to be collected, then this is a blatant violation of your right against self-incrimination. And this is a fundamental right. Because you know this, you are the perpetrator. And in case where your DNA samples are taken or collected by the investigating agencies, they are for sure going to be matched by the material they have already collected, by anything they have already collected. So this would amount to be a witness against himself. Okay, and because such information qualifies as a physical act similar to a handwriting sample. For example, if some handwriting has to be matched and you are being compelled to write anything in your writing by your hand, this also amounts to self-incrimination. But Article 20 Clause 3 says, no man shall be compelled to be a witness against himself. Now, when this is the law, when this is the fundamental right, how can the investigating agencies force any individual to be a witness against himself? Be it the oral testimony, be it the material evidence, or the production of any documentary or material or scientific evidence, including DNA samples. Okay. Prablin says Selvi versus the state of Karnataka narco analysis. That's right. Selvi versus the state of Karnataka is a judgment on narco analysis. Narco tests there are cases on narco analysis also. How far they amount to, like, this amounts to a complete violation of right to privacy and right against self-incrimination. Okay. It is not the job of the accused to produce the evidence. It is the job of the investigating agencies to collect the evidence from anywhere. Okay, from anywhere. So, the accused should not be compelled to be a witness against himself. Rather, the investigating agencies should themselves do something to collect the evidence to get the accused convicted. Okay. Physical facts cannot be considered to be in the knowledge of the accused person and are therefore not violative of Article 20, Clause 3 of the Constitution. Consequently, it is easy to argue that DNA, by virtue of being a biological and a physical fact as a fingerprint, would not be a violation of Article 20, Clause 3 of the Constitution. Okay? Consequently, physical facts cannot be considered to be in the knowledge of the accused person and are therefore not violative of Article 20, Clause 3. Now here, the author of this article is trying to say that physical facts do not qualify the ingredients of Article 20, Clause 3. And consequently, it is easy to argue that DNA, by virtue of being a biological and physical fact as a fingerprint, would not be a violation of Article 20, Clause 3 of the Constitution. Okay. However, such an argument ignores the fundamental difference in a fingerprint and a DNA profiling. It must be noted that DNA profiling is substantially different from fingerprint evidence for two main reasons. Firstly, DNA profiling, unlike fingerprinting, can be used for tracking behavioral, temperamental, habitual traits of people. Okay. DNA profiling is done to track the behavioral, temperamental and habitual traits of the people. Prableen says that in Kathi Kalu Ongad, it was stated that DNA comes out of the scope of Article 20, Clause 3. See, Prableen, I'm not trying to say that narco-analysis or DNA samplings, they fall within the scope of Article 20, Clause 3. Here, the writer of this article, the author of this article, has tried to pose two different contrasting things together. That on the one hand, the writer himself says here that it is a biological and physical fact and it does not amount to the violation of Article 20, Clause 3 of the Constitution. But in the very next paragraph, he is trying to rebut this argument. This is not what the arguments can see. There is not a violation of Article 20, Clause 3 of the Constitution as per many judgments of the Supreme Court. But at the same time, there are certain things which needs to be contended now before the Supreme Court, because the Supreme Court can change its view. It has changed in many of the cases. It can change its view. It is just a discussion which is going on here. We are not discussing a full-fledged stated law here. We are just discussing a case here. Such an argument ignores the fundamental differences in a fingerprint and DNA profiling. It must be noted that DNA profiling is substantially different from fingerprint evidence for two main reasons. Firstly, DNA profiling can be used for tracking behavioral, temperamental, habitual traits of people. This information is more than a mere physical fact and can be categorized as knowledge possessed by the accused. Obviously, if the behavioral or temperamental and habitual traits of the offender are involved in the crime, for example, if a crime was committed in a particular way, if a crime was committed in a particular way, some temperamental things of the offender are involved in it, some habitual traits, through the habitual traits of the offender he can be traced, then DNA sampling would help us to reach the perpetrator very easily. And this is something, the knowledge possessed by the accused. When can something which is already in the knowledge possessed by the accused, anything which is in the knowledge possessed by the accused, that will fall under the category of Article 20, Clause 3. Because only in those cases where the knowledge is possessed by the accused himself, he cannot be compelled to be a witness against himself. But in cases, in evidences which are beyond his knowledge, Article 20 Clause 3 would not qualify here. Like the DNA samples. DNA collection of DNA samples does not fall within the knowledge of the accused whether his DNA is going to be matched or not. Therefore, DNA samples, in the previous paragraph, are stated to be outside the purview of Article 20 Clause 3. When can a man be compelled to be a witness against himself? When he knows something, when he has knowledge that revealing of some facts would incriminate him in a crime. Right? Would incriminate him in a crime. But what about the facts? What about the physical facts which are beyond his knowledge? DNA samples are beyond his knowledge. So collection of DNA samples would not amount to compelling him to be a witness against himself, because it is beyond his knowledge. By virtue of that, tracking such information and arresting people based on such information would amount to a violation of right against self-incrimination. Okay, if we are tracing the tracking behavioral, temperamental, habitual traits, then it will amount to violation of right against self-incrimination under Article 20 Clause 3. So this article, it's a mixed blend of pros and cons of the DNA sampling, how far it is falling within the purview of Article 20 Clause 3 and how far it is falling outside the purview of Article 20 Clause 3. Secondly, fingerprinting, owing to its one-time usage application, cannot be used by the investigating authorities for harassing repeated offenders in the future. Okay, because collection of fingerprints can be used only in one case. It cannot be further misused. Okay, if fingerprints are matched, then it's all right. But if they are not matched, then they are of no use for the investigating agencies. So the collection of fingerprints is not a point of concern at all. But the collection of DNA samples or DNA profiling of an individual is a point of concern, because such DNA profiles are stored in a database and they are readily available to the state on a mere click of a button, and they can be used for the same again and again in any of the case. Fingerprints become useless after the case is properly investigated. But DNA profiling, it can be used again sometimes to trace the temperament of the offender, sometimes to find out the habitual traits of the offender, sometimes to match the behavioral patterns of the offender. So they can be used again and again. That is how it leads to violation of Article 20 Clause 3 and violation of privacy. Therefore, by virtue of its ability of recreating a number of psychological and behavioral traits about people, DNA is much more than a physical fact, and using that as a basis for trying offences would be nothing short of self-incrimination, thereby violating the protection offered by Article 20 Clause 3. Okay? By virtue of its ability of recreating a number of psychological and behavioral traits about people, DNA is much more than a physical fact, and using that as a basis for trying offences would be nothing short of self-incrimination, thereby violating the protection offered by Article 20 Clause 3. So I guess you all have understood, I believe you all have understood what is discussed here. Okay, what is discussed here? Not the least restrictive method of identification. Least restrictive method of identification, coming to the requirement of necessity as clarified in the Aadhaar judgment. The state will have to justify the bill is the least restrictive measure of achieving its goal. The goal as stated in the bill is establishing the identity of certain categories of persons, including the victims, offenders, suspects. With the legislation as deeply intrusive as this, it becomes imperative to think about the kind of goals the state is trying to achieve in the first place. Like we are supposed to test the constitutionality of any law on the three grounds: legality, necessity, and proportionality. So in the first place, what is to be tested? That what are the goals the state is trying to achieve? Okay. What are the goals? Why this law has been brought by the state? So what are the goals? What would this establishment of identities possibly achieve? Why the state is trying to create the establishment of identities? And what could the state possibly achieve by doing this? Besides a serious threat to the safety of people on the list, an investigative machinery relying heavily on this database to solve crimes would also trump the concept of presumption of innocence protected under right to fair trial. Okay. Besides a serious threat to the safety of people on the list, an investigative machinery relying heavily on this database to solve crimes would also trump the concept of presumption of innocence protected under right to fair trial, even if the state is able to justify a legitimate objective behind the bill. Its provisions are likely to fail the least restrictive measure test, as there are equally effective alternatives mechanisms to it. For example, the alternative methods could involve an erasure of the DNA samples of all suspects and their family members once the trial is over, determining a time limit for recorded offences, or restricting non-consensual DNA collection to very specific instances. Okay. The alternative methods could involve an erasure of the DNA samples of all suspects and their family members once the trial is over, determining a time limit for recorded offences, or restricting non-consensual DNA collection to very specific instances. Such provisions have proven fruitful in countries like the US and UK. Moreover, there is evidence to suggest that DNA profiling may not even be the most accurate way of identifying individuals, due to eventualities like blood transfusion, bone marrow transplants, and other instances of presence of multiple genomes in the human body. In that case, collection of DNA samples will not even be the most effective method of identification, let alone the least restrictive one. Okay. DNA profiling may not even be the most accurate way of identifying individuals due to eventualities like blood transfusion, bone marrow transplants, and other instances of presence of multiple genomes in the human body. In that case, collection of DNA samples will not even be the most effective method of identification, let alone the least restrictive ones. Now, fundamental right to privacy versus larger public interest. This is also an issue. Sometimes public interest is very important. It is as important, and that even its overshadowing of any fundamental right is inevitably ignored. On the issue of proportionality, the state would try to justify the bill on grounds of a larger public interest of a speedy justice delivery. An argument of balancing of a state interest with the rights of the citizens could be made on grounds of judgment like Bhavani Prasad Jina versus Convener Secretary, which explicitly called for an exercise of balancing of interest by the court in any case where an accused refused to undergo medical examination. See, sometimes there are public interests involved, and wherever these public interests are larger than the issue of any fundamental right, the public interest is given due heed. Okay. In cases of Aadhaar card, the Supreme Court was of the view that the policy of Aadhaar is also very necessary, while the issue of the violation of fundamental right is also very necessary. But sometimes some public policies like that of Aadhaar are very necessary, and in such cases we have to ignore the violations of fundamental rights. So the court applied a balanced view. The balanced view was that the Aadhaar cards should be used only by the government agencies and not by any private entities. Okay. So the Aadhaar policy was allowed, as also keeping in view the violation of the fundamental right to privacy. Same, the case was stated, that is stated here, is Bhavani Prasad Jina versus Convener Secretary, which explicitly called for an exercise of balancing of interest by the court in any case where an accused refused to undergo medical examination. However, even for claiming compelling state interest as understood in Anuj Garg versus Hotel Association of India, under the broader strict scrutiny test, the state would have to demonstrate that it has adopted a method that infringes the fundamental rights in the narrowest possible manner, so that a delicate balance is maintained between the fundamental rights of the individual and the larger interest of the society. Okay. would have to demonstrate that it has adopted a method that infringes the fundamental rights in the narrowest possible manner, so that a delicate balance is maintained between the fundamental rights of the individual and the larger interest of the society. There is a very delicate balance. There is a very thin line of difference between the fundamental rights of the individual and the larger interest of the society. It is in the larger interest of the public or of the society that the perpetrators of the heinous offences should be apprehended, and the investigating agencies should be given a free hand to apprehend them by way of DNA sampling or do anything to apprehend them. No matter what, no matter if their fundamental rights are violated, this shouldn't be an issue at all. Therefore, it will be tough for DNA profiling, which violates the fundamental right to privacy and the inherent rights of the accused, to meet the larger public interest exception. Moreover, recent trends suggest that the question in courts is not simply a matter of personal privacy versus public interest. Rather, the modern perception of how public interest in respecting personal privacy is increasingly gaining importance. Okay, now public interest, sometimes there is a question now that the public interest also lies in respecting personal privacy. And this is increasingly gaining importance. Therefore, any balancing of interests that may be done by the court in deciding the validity of this law must be done keeping in mind the above parameters. Now, what is the conclusion? The bill currently stands without any procedural safeguards to prevent the leakage or manipulation of DNA samples and makes no distinction between convicted or under trial prisoners, accused or suspects. Not only does this bill pose a threat to the fundamental rights of accused, under trials, suspects, but also has the possibility of substantially affecting the lives of their family members. As Justice Chandrachud said, constitutional guarantees cannot be subject to the vicissitudes of technology. In light of this, we must decide how much faith we want to place on the reliability of DNA samples, especially when we live in an age where the evidentiary value of DNA samples remains debatable. This is completely a debatable issue now, because there are so many complexities and complications involved, that how far it is violating the privacy, and whether if it happens to violate privacy, how far it is in the larger public interest to allow such this proportion of violation. Then how far it falls within the knowledge purview of the accused, so that it may be proven to be a violation of Article 20 Clause 3 right against self-incrimination, and how far it falls outside its purview. There are so many complications, and it is still a debatable issue. There are no concrete arguments in either favor or against it. In conclusion, the DNA Technology Regulation Bill 2019 clearly ignores the security and privacy considerations of citizens, fails the constitutional tests as evolved in Puttaswamy, and therefore must not be passed without careful considerations of its future implications. So this is about the DNA Technology Regulation Bill 2019 and various constitutional provisions. Now, your questions are most welcome. If you have any questions, if you have not understood any point, you're most welcome to ask. Please go ahead. Ankita is asking till which date it is going to continue. Um, what? Are you asking about what? Ankita, what are you asking about? About session, it will continue so long as your up till your CLAT exam. Any other question? I'm waiting for your questions. Gautaman is asking if DNA technology is useful for crime against accused. Yes, exactly. It's very useful. It brings out the perpetrator right in front of the investigative agencies. Of course, it is very important. It is very useful. It becomes very easier for the investigating agencies to apprehend the offender. Once these DNA samples are matched with the evidences collected on the crime scene, it becomes very easy for the person to be apprehended. That's very important. But the whole discussion and debate is about how far this is allowed, how far this is feasible and proportional to the violation of privacy and Yes, exactly, Ankita. Okay, then, so no more questions are there, I guess, and I'm ending the stream now. Okay, we shall meet next week with the list of judgment summaries, and then with a list of judgment summaries, and we shall meet next week. Okay, till then, all the very best. Enjoy your weekend. Have a good day, and bye bye.